Hello, everyone, and welcome back. So, what's on tap for today? Well, we've got another great reaction video of one of our favorite senators, Ted Cruz, questioning Ketanji Brown Jackson on why she gave such light sentences to hardened criminals and hardened felons, thereby, really, in other words, very little justice for the victims. We're going to get to all that in the next few seconds, but if you haven't already done so, subscribe to the channel. You're watching the Dr. Nasir Shaikh Show. I'm your guest host for today. My name is Dr. Nasir. Hit that notification bell, like, share, and follow us. Put your comments below. Tell us what you think of Ted Cruz and Ketanji Jackson. And let's get to that video right now.
And I'll confess, Judge Jackson, as I listened to your testimony, I believe you are someone who is compassionate. I believe you care for children, obviously your children and other children. But I also see a record of activism and advocacy as it concerns sexual predators that stems back decades and that is concerning. You wrote your note on the Harvard Law Review on sex crimes. Your note is your major academic work on the Law Review, and yours is entitled Prevention versus Punishment Towards a Principled Distinction in the Restraint of Released Sex Offenders. And in it, you argue, and I quote, a recent spate of legislation purports to regulate released sex offenders by requiring them to register with local law enforcement officials, notify community members of their presence, undergo DNA testing, and submit to civil commitment for an indefinite term. Although many courts and commentators herald these laws as valid regulatory measures, others reject them as punitive enactments that violate the rights of individuals who have already been sanctioned for their crimes. Under existing doctrine, the constitutionality of sex offender statutes depends upon their characterization as essentially preventative rather than punitive. And what you go on to explain is if they're viewed as punitive, they are unconstitutional. If they're viewed as preventative, they are not. And throughout the course of your note, you argue they should be viewed as punitive and therefore unconstitutional. Indeed, in the second to last page, you go through each of those four categories. You say requirements that sex offenders register may or may not be unconstitutional, depending upon whether, quote, in which sex offenders have no privacy right in registration information or blood samples. So you suggest that may or may not be constitutional, although you raise doubts about it. And then you raise very significant doubts about community notification, and you heavily suggest that civil commitment for sexual predators is unconstitutional. Do you still agree with the sentiments you expressed in your law school note?
Respectfully, Senator, those are not the sentiments that I expressed in my law school note. My law school note was about sex offender registration laws, which at the time were relatively new. As you know from our time in law school, one of the things that law school students do is they look for new developments in the law and they try to analyze them. That's something that makes for good fodder for a law school note. My note, which came out in 1996, was shortly after there were new Megan's laws. And the point that I was making was not that the laws were bad, that the laws were wrong. I was trying to assess something that is sort of fundamental in terms of the characterization of the laws. I didn't say that they were unconstitutional one way or the other. What I was trying to assess was how they are characterized. Some courts would look at those laws and call them preventative, and that has a certain set of consequences. Some courts would call them punitive, and that has a certain set of consequences. And what I was trying to do is figure out how to make the determination, whether they were punitive or preventative.
Well, your note argued that they were punitive, and I would note that view, there have been some on the bench that have advocated that. The Supreme Court in 1997 decided a case called Kansas versus Hendricks, in which it upheld Kansas's civil commitment statute. That was a 5-4 vote. This has been a question that has been close at the Supreme Court. And I would note beyond that, that in terms of the prevalence of these statutes, all 50 states and DC have registry requirements. 47 states have community notification requirements. All 50 states have DNA or blood banks for sex offenders requirements. And 20 of the states, the federal government in DC, have laws that allow for the indefinite detention of sex offenders. I would note in the state of Texas, a state court of appeals, relying on very much the same sort of reasoning you advocated in your note, struck down Texas's sexually violent predator civil commitment law. At the time I was the Solicitor General of Texas, I personally argued that appeal in the Texas Supreme Court. And the Texas Supreme Court unanimously reversed the Court of Appeals and upheld our statute. And if the views you advocated in law school prevailed, civil commitment laws across the country would be struck down, releasing sexual predators. And under the argument, community notification and DNA bank laws could well be struck down as well. Is that an outcome that should concern people?
I've got to chime in here, folks, right now. This whole thing, as you see, so she wrote a note basically saying that these laws that were in effect, if they were punitive, if they were deemed as punitive in the eyes of the judge or whoever was looking at this, then they were basically unconstitutional. But if they were trying to preventative or, go see a doctor, let's try to analyze your feelings, let's try to do, go to a psychiatrist, visit a psychologist. If that was okay, those are perfectly fine. In other words, what was going on is that it's written down there, plain as day, black and white. Yet she goes, that's not what was in my note. I was just a law student, that's all I was doing. I was just a law student. We law students, we look for new laws that come out so we can basically, write about them and give our opinions. No, you were on the side of the felon, of the rapist, of the child molester. That's whose side you were falling on. You were not falling on the side of why didn't you argue why other people would have done it? Most people, that are looking to help the victim, be on the side of the victim, they would be what? They would be arguing that, punitive is fine. You did it, you do the time for the crime. And if there's nothing punitive about jail sentences, nothing punitive about DNA registry, there's nothing punitive about registering you as a sex offender if that's what you did, nothing at all. In fact, it should go beyond that, much more beyond that. These are just very simple things. There's nothing punitive about them. Let's continue.
Senator, my note wasn't advocating for the striking down of those laws.
Yes, it was.
My note was trying to identify criteria that I thought could be applied consistently to determine whether the laws were punitive or preventative.
But with respect to Jackson, you argued that they were punitive, and you further say in the note, if they're punitive, they're unconstitutional.
I was looking at 4 different kinds of laws, and not all of them, did I say, were punitive.
Okay, so let's take civil commitments laws. If you look at civil commitment laws right now, the UCLA School of Law, Williams Institute, estimates more than 6,300 sex offenders are currently detained in civil commitment programs. If the view you advocated prevailed, presumably those 6,300 sex offenders would be released to the public. Is that an outcome that should be concerning?
Senator, in law school, when I was writing a note, I was looking at a brand new set of laws.
Here we go
that had
again.
Not previously been enacted in any jurisdiction. They were new. And I was assessing at the time, as law school students do, what criteria I thought might be used by courts to make a determination in the future as to whether or not they should be treated as punitive and therefore not unconstitutional, but as therefore ones that carry with them certain rights versus, preventative.
Judge Jackson, so you've pointed that these were views in law school, and listen, I will recognize that all of us, when we are students, may have views that as time and maturity passes on, we may change. But what troubles me is this was not just a law school view. It's one that has continued. So when you were vice chairman of the Sentencing Commission, you expressed significant concerns that the White House has argued that your quotes were taken out of context. So I want to provide the full context of your quote, because you said, yes, I want to ask you about the means by which we can distinguish more or less serious offenders. I know that all of you sort of touched on that. Mr. Futrell, you talked about going from singular to one-on-one to group experience. I'm just wondering if there's some sort of inevitable and natural progression from one stage to the other, such that you could say that the least serious offenders are in the singular experience stage. And I guess my thought is, in looking at some of the testimony that other people will have later in the day, I was surprised at some of the testimony with respect to the motivation of offenders, and we're talking about child pornography offenders, and that there are people who get involved with this kind of activity who may not be pedophiles and who may not be necessarily interested really in the child pornography, but have other motivations with respect to the use of technology and being in the group. And here are lots of reasons perhaps why people might engage in this. And so I
just got to stop this right here. This is absolutely this is unfreaking believable. This is unbelievable. She's actually saying that some people that get involved with this kind of activity, they're just interested in the technology. They just, brand new camera. Got a brand new camera here. I think that's unbelievable. Great technology. You know what? Let's take some pictures of some kids. Yeah, that's a good idea. I got this new tape recorder. I think I'm going to tape some kids, underage kids. And then you know what? I love filmmaking. I'm going to take some photographs. I'm going to put them up, and I love pictures of underage minor kids. Just a technology. This lady, okay, unbelievable. She, liberal, woke, social justice warrior, progressive, doesn't give a damn about the victims.
Wondering whether you could say that there could be a less serious child pornography offender who is engaging in the type of conduct at the group experience level, because their motivation is the challenge or to use the technology. They're very sophisticated technologically, but they aren't necessarily that interested in the child pornography piece of it. Now I find that a pretty remarkable argument, that people in possession of child pornography are not actually interested in the child porn. They're not pedophiles. They're just interested in technology. Is that? And I wanted to provide the whole quote because the White House said that portions of this were used out of context. So this is your entire quote. Do you agree with that sentiment, that there is some meaningful population of people who have child pornography but are not, in fact,
They're
pedophiles
good guys.
or getting satisfaction from it?
Thank you, Senator, for allowing me to address what appears to be a question that I was asking in the context of a hearing on child pornography. You've provided the entire...
Only a moron would ask a question like that. Person under the acronym of SIMMER. Only a person who is stupid, only a person who is idiotic, only a person who is moronic, only a person who is retarded would ask that type of a question. That people that are peddling in child pornography, in being child molesters, that's not who they really are. They're just interested in the technology. That's what they're there for. She's part of SIMMER.
Quote, and it looks as though I was asking that of someone, not taking that position. And the position that I've taken in all of my sentencings involving child pornography offenders is to ensure that despite the attitude and view of many of the offenders who came before me when I was a trial judge, that they were just lookers, that they weren't really harming anyone, that they were curating their collections and they never touched a child, I made sure that they understood that notwithstanding their collecting behavior, that they were causing significant harm.
So Judge Jackson, all right, you raise your actual sentencing, and I think that's very productive. Let's take a look at your actual sentencing. And you've had 10 different cases involving child pornography.
Here it comes.
These are the cases. There are two, U.S. versus Buttry and U.S. versus Can, for which the government did not make a recommendation. And you said earlier, when Chairman Durbin was trying to preempt this line of attack, you said it's a sickening and egregious crime, which I very much agree with. And you said the guidelines lead to extreme departures. Okay. Let's look at what the prosecutors are asking for. And I would note that this was in the District of Columbia, where prosecutors are far more liberal than many of the prosecutors in this country. And in every case in which, so United States versus Hess, there was a mandatory statutory minimum of 60 months, and you imposed 60 months because you had no discretion. In United States versus Nickerson, there was a mutual agreement of the parties to 120 months, and that's what you imposed. In every other case, United States versus Chazen, the prosecutor asked for 78 to 97 months. You imposed 28 months. 28 months is a 64% reduction. In United States versus Cooper, the prosecutor asked for 72 months. You imposed 60 months. That was a 17% reduction. In United States versus Downs, the prosecutor asked for 70 months. You imposed 60. That was a 14% reduction. In United States versus Hawkins, the prosecutor asked for 24 months. You imposed 3 months.
I gotta stop this. How the hell do you give a child? This is the Judge Act is the sentencing of child pornography offenders, right? Child pornography. They asked for 24 months. She gave 3 months? It's just like a slap on the wrist. God almighty, this is unbelievable. This is what we're talking about. You get these. Let's continue.
That was an 88% reduction. In United States versus Savage, the prosecutor asked for 49 months. You imposed 37. That was a 24% reduction. In United States versus Stewart, the prosecutor asked for 97 months. You imposed 57. That was a 41% reduction. Every single case, 100% of them, when prosecutors came before you with child pornography cases, you sentenced the defenders to substantially below, not just the guidelines, which are way higher, but what the prosecutor asked for on average of these cases, 47.2% less. Now, you said you made sure the voice of the children was heard. Do you believe in a case like United States versus Hawkins, where the prosecutor asked for 24 months and you sentenced the offender to only 3 months? Do you believe the voice of the children is heard when 100% of the time you're sentencing those in possession of child pornography to far below what the prosecutor's asking for?
You don't give a damn about
Yes,
the victim.
Senator, I do.
No, you're an idiot.
I will.
Explain.
A couple of observations. One is that your chart does not include all of the factors that Congress has told judges to consider, including the probation office's recommendation in these cases.
Well, Judge Jackson, we don't have those probation. The committee has not been given the probation office's recommendation. We would welcome them. Mr. Chairman, I would love to see those. We don't have access to them.
The second thing I would say is that I take these cases very seriously.
No, you
as
don't.
A mother.
You're not taking it as a mother.
As a judge, has to review the actual evidence in these cases and, based on Congress's requirement, take into account not only the sentencing guidelines, not only the recommendations of the parties, but also things like the stories of the victims. Also things like the nature and circumstances of the offense and the history and characteristics of the defendant. Congress is the body that tells sentencing judges what they're supposed to look at. And Congress has said that a judge is not playing a numbers game. The judge is looking at all of these different factors and making a determination in every case based on a number of different considerations. And in every case, I did my duty
No, you
to
didn't.
hold the defendants accountable
No,
in
you
light
didn't.
of the evidence and the information that was presented to me.
Liar.
100% of the cases, was the evidence less than the prosecutors asked for?
Senator, the evidence in these cases are egregious. The evidence in these cases are among the worst that I have seen, and yet, as Congress directs, judges don't just calculate the guidelines and stop. Judges have to take into account the personal circumstances of the defendant because that's a requirement of Congress. Judges have to consider things like the victims, and when I was talking about making sure that victims' circumstances are heard, it was about my sentencing practices.
Which are
that
terrible.
No victims being heard, with respect. Thank you, Mr. Chairman.
This lady right here, this picture, this smug face right here says it all, says everything that you need to know about the corruption, the absolute wokeness, the social justice warrior that these people are, that these progressives, they don't give a damn about the victims. They don't give a damn about the mothers and fathers whose children have had to endure this absolutely egregious, heinous, evil act of being molested as a child, being used in child trafficking, used in child porn. This lady has children herself, and I would want to know that if God forbid something had happened to, in her family, and a judge had a chance of putting somebody away for 10 years and said, well, I've been looking at the things that Congress says, and I got to look at all these other factors that are out there, and I got to take a look at the sentencing guidelines, and the mandatory minimum is 20 years. The prosecution is asking for 10. I think in my expertise, and who gives a damn about the victims, I think that I'm going to side with because I think that he can be rehabilitated. So instead of giving the prosecution wants 10 years, I'm just going to go ahead and give, I don't know, 2 years, 24 months. And I think that's enough. That's 100% of the cases, she went under the guidelines that were being given by the prosecution in 100% of the cases. And she has the nerve to say that she was doing her job? Folks, that's what's wrong with the legal system, is that when you have got progressive people like this, when you have leftists like this, socialists like this is, people that don't, again, like I said, side with the criminal element, side with the pedophile, side with the child molesters, to side with the people peddling in pornography, and they don't give a damn about the victim at all. They don't. She's the poster child for that. This is the face right here. Anyways, we appreciate you taking the time to watch. You've been watching the Dr. Nasir Shaikh Show. I've been your guest host. My name is Dr. Nasir. Like, share, and follow us. Subscribe to the channel. Hit that notification bell. Put your comments down below. Tell me what you think about Judge Brown, Ted Cruz. Tell me what you think about my comments. Was I on point, or do you differ, or you say that I'm completely wrong? Anyways, I'll leave you with my final thought, which is, when you're right, you're right. And when you're left, you're wrong. We'll see you again next time, folks. Take care and stay safe.